Good evening to one and all. It's my pride privilege to be associated with this learned house or gathering here. I'm really very thankful to Judith for pushing me to write a chapter and to contribute to the upcoming book on platform regulation. I also take the opportunity to thank Professor Byrne for mobilizing the young minds to work and to come out with their studies on the very crucial aspect on platform regulation. Well, briefly, I would like to introduce myself. I am assistant professor at Faculty of Law, University of Delhi, and University of Delhi is almost a century-old institution in India. And my institute, my faculty, that is Faculty of Law, is also about to complete centenary in 2022. So we have a rich, faculty base here, and this institution has one very important feature which I would like to highlight. We are an egalitarian institution teaching almost 10,000 students at a very nominal fee here in India. So it's a central university, public funded university, and the students from different parts of the country, from various states, do come to study here, right? So I focus, or my area of research primarily is intellectual property laws and information technology law and antitrust laws. And I focuses primarily on the interface between the three subject, IP and information technology interface specifically. Recently, I have started taking keen interest in antitrust issues also. We have introduced antitrust, or you can call competition law, as an elective paper and optional paper for our graduate students, LLB, or you may say law students here in India recently. Well, now I would like to come to my presentation on platform regulation in India. Until recently, in India, social media platforms were not regulated by any specific guideline or a rule, you may say so. But in of late, in February 2021, the government of India, through its nodal ministry, that is Ministry of Electronic and Information Technology, brought certain changes into the Information Technology Act, which is an old act in India, that is year 2000 Act, which is a primary law on the subject. They brought a new guideline that is called Intermediary Guideline and Digital Media Ethics Codes 2021. That was brought very recently in February 2021. And 3 months transition period to all the intermediaries, including social media intermediaries, was given for the implementation of certain additional procedural requirement by all the intermediaries, including social media intermediaries. I'm highlighting social media intermediaries because social media intermediaries were never ever part of any of the law or legislations in the country prior to this new guideline, which had been brought recently in February 2021. So it has certainly created a lot of chaos amongst the significant social media intermediaries and social media intermediaries, because they have been imposed to abide certain additional requirements or procedural requirements, which are problematic, especially problematic in the context of privacy of the users of those platforms. WhatsApp had recently filed a few days ago, only in this last week itself, WhatsApp had filed a lawsuit in High Court of Delhi against the government of India for bringing in these intruding guidelines on intermediaries. The WhatsApp and there are other intermediaries also who had approached the high courts in different states they had all challenged the constitutionality or the legality of the new rules. The new rules are problematic specifically in relation to certain aspects, which I would like to highlight in my presentation by giving you a preface of what is happening in India as far as the background of the platform regulation is concerned. Well, I would gonna share my screen quickly if I'm allowed to do that. I believe I have been allowed. So I am going to share it. Is it visible? Is my screen visible to all?
Not yet.
Not yet. Okay. Give me a minute.
But you should be allowed to.
Okay. Yeah, I'm doing that. Is it visible now?
Yes.
Okay. Well, we know that everyone knows that India is a very populous country and we have a mammoth user base. The figures are there on the screen. We have so many WhatsApp, Facebook, Twitter users and YouTube users, perhaps outweighing the total number of users of my co-speakers today and into their respective jurisdictions. So this is really, alarming so far as the issues pertaining to handling of data and privacy is concerned. But as a business prospect, it is very interesting for these big tech companies, Facebook, Twitter, or WhatsApp for that matter. The regulatory framework in India is basically it's a blend of the legislative and policy framework, which has started emerging recently. As I said and mentioned in the beginning, that the social media intermediaries or the platforms were not kind of non-est or non-existing into the guidelines and the regulations until 2021. We certainly had information technology law, but that is not a law that caters to the platforms or that regulates the platforms. The platform regulation was completely absent in the same. The current Indian legal framework on social media platform tend towards a mixed or you may say co-regulatory model, relying both on statutory and self-regulation of social media platforms. So the self-regulations and statutory framework are continually active in deciphering the broader contours of social media platforms in India, in addressing the legal niceties also. But the problem is that the word platform has not been defined anywhere so far in any of the legislations or rules in India. The new rules, which are the specific focus of my contribution or into my research, these intermediary 2021 rules, they define social media intermediaries and significant social media intermediaries. The attempt has been made for the first time to delineate the social media platforms as a separate category as intermediaries. Prior to the 2021 rules, the recently contentious rules, I may say, there was no mention of social media anywhere in any of the laws in the country. So this is one problem. So you may say that it is a maiden guideline or maiden approach in the country. The framework, the present framework, posits certain key questions. Now the challenging part of my presentation. Perhaps all of you must be suffering in your respective jurisdictions so far as this component of free speech is concerned. So the legal and policy framework has been continually very active, but how far this activism stands true to the basic tenet of free speech? This is something worrying. Is the basic right of free speech being curtailed under the guise of newer and more regulations which are alleged to have, of course, troubled past and flawed procedural making. Let me bring one more important fact to the notice of the audience here, that these new rules, or you may say these new guidelines on intermediaries, including social media intermediaries, have been brought very quickly, unlike the previous guidelines, which used to take a lot of brainstorming amongst the parliamentarians, amongst the lawmakers. But these guidelines have been quickly and swiftly brought and have been asked by these intermediaries to be implemented at a very expeditious, in a very expeditious manner, which is problematic. And that is why WhatsApp had challenged through a lawsuit in High Court of Delhi. In this week itself, they have filed a lawsuit, apart from other digital media houses who had gone to courts in the country challenging the constitutionality and legality of the 2021 rules. So this is one issue where free speech it may get jeopardized. I can't say that it will really get jeopardized at this juncture, because these are the new rules, and the implementation is yet to take place of these rules. So let's hope that they are going to promote the free speech as envisaged by the government in the very objective of these rules. But what seems from the reading, from the meticulous reading of these rules, is that they are going to take away the privacy for right, because WhatsApp or messaging platforms, specifically the messaging platforms like Telegram and WhatsApp, those who have 5 million user base in India, they are termed as significant social media intermediaries, right? And they are different from social media intermediaries, because the government has kept this power to determine as to who will be called the significant social media intermediary, and they keep a threshold and they notify a threshold on the basis of which the intermediary's status or nature would be determined. So any messaging service provider, if has a user base of more than 5 million in India, they will be termed as significant social media intermediary, and they have additional burden, or you may say they have the responsibility to abide certain additional guidelines, which are completely different vis-a-vis to social media intermediaries. Or you may say the intermediaries having less number of users in India. So the objectionable part of the same is that those who are significant social media intermediaries, they have to open their operations, or you may say their office in India. First of all, this is one of the first requirements. Then, or you may say first additional requirements. Then they have to appoint one officer who can be held liable tomorrow for any wrong dissemination, or you may say for third-party content being hosted through the platform, or in the case of spread of any disinformation. This is what WhatsApp is objecting to. WhatsApp says that we can't appoint a person in India to be made liable under the Indian laws for for our role as intermediaries. We are just intermediaries. We are not playing any crucial role in the filtering of the information, or in the scrutiny of the information. And it is impossible also, given the number of users we have subscribed with the messaging services. So undoubtedly, this is one objection of appointment of the nodal officer and the key person who can be held criminally liable or accountable tomorrow by the government of India. Another issue in the WhatsApp petition on the challenge of these new rules is that they have been bestowed with the task of keeping the track of originator of a message or of any information. That is another problematic area where the WhatsApp is contending. WhatsApp is saying that we can't keep originator traceability. We can't trace the originator of the information. Especially, we have to uphold the privacy of the users of our platforms. And the government guidelines, the recent or the new guidelines in this regard, requires WhatsApp specifically to trace originators of the message, especially in the context of disinformation and fake news being spread or disseminated through the platform like WhatsApp in India. So they're contending and challenging it on the basis of privacy, which is considered a fundamental right in India, especially post 2017, when the apex court in the country, that is Supreme Court of India, pronounced a very interesting judgment called Puttuswamy judgment, where right to privacy was held as fundamental right in the country. So, and one more issue, which is rather technically, where WhatsApp is pitching, it says that end-to-end encryption platforms are vulnerable to falsification and impostering. So they place their inability to trace the originator, being intermediaries in this case. So this is what is happening right now, and these developments are very recent. This week itself, WhatsApp has gone to High Court of Delhi, challenging the constitutionality and legality of these rules. Prior to that, some digital media houses, especially the news or current affair intermediaries, they had also approached the court, challenging the impugned part of the present guidelines, because as per the new guidelines, even the digital media houses are called the intermediaries, or they have also been included in the ambit to be called as intermediaries, and they have to abide by all the requirements if they have a user base of more than 5 million, or in case if they have a less user base, still they have certain requirements which they are objecting to, or you can say vehemently objecting to. They had also gone to the court challenging the legality and the power of the government by purview of the information technology law, which primarily is in context of the e-commerce, and you can say for legalizing the e-commerce, and it does not have anything in its sweep in relation to regulating the social media. So they are claiming that this move of the government is an overreach, or you may say is kind of a camouflage by which they can tame or control the free speech in the country. Well, so far as the statutory framework is concerned, as I have highlighted, there's no omnibus legislation to govern platforms. The regulations, the laws, the statutory or other things are spread across several laws, especially Constitution of India, where right to privacy is a fundamental right. Then Information Technology Act is the most important act, but it is also not an omnibus legislation or a law for regulating the platforms or social media platforms. Rather, I would say that it is completely silent on the platforms or social media. It is only through the corresponding rules under the IT Act or under the Information Technology Act 2000, the government had brought the intermediary guidelines and digital media ethics codes 2021, right? And government proposes a hybrid model where they say you may have your own self-regulations along with the statutory regulations. And I would highlight or would like to highlight the problematic statutory regulation here, where the government requires the intermediary or a platform for appointing the nodal officers on the one hand. Apart from that, the ministry, the concerned ministries like MITI in India, which is called Ministry of Electronics and Information Technology, And there is another mystery which was there in framing these rules, that is Ministry of Information and Broadcasting. So these ministries will have their own secretary level persons appointed in their statutory regulations for regulating the platforms. So the platforms or intermediaries are objecting to it, asserting that the government intervention by appointing their own officers would be problematic to the free speech here. So this is the present model through which government is trying to control. I would like to critically analyze the present guidelines in a quick manner.
Ashwini,
okay.
I'm very sorry to interrupt you, but you are substantially over the time.
Fine. Okay, I would conclude here. I believe I had already discussed all the things which are there on the screen. I had already covered all these aspects in my speech. I would be happy to take questions if there are any. From my side, it's over.